Okay, it is 10:30 right now. I'm not sure if folks have had a chance to come over from the other session yet.
Yeah, I was thinking there might have to be a few minutes of turnover.
Yeah.
Let's see.
So I know we do need to end just about or start wrapping up about 5 minutes early or before the end of the session, Tracy. So if you want, I can just give you kind of there's Joe. I see him in the comments.
That would be perfect. Yes, that would be great.
Wonderful.
Well, and remember, I can't see comments though, so do it. Make sure you do it verbally.
Yep.
Okay.
Okay. So Joe did just say Lisa's just wrapping up.
Okay.
So we'll just wait just a couple more minutes and then get started.
Sounds good. I'm looking at the hummingbirds outside my window. So.
Oh, I love it. I'm actually going to get a feeder, I think this weekend, because I just want to sit and watch them.
Yeah. That's one thing I miss from working from home is my office at home. I have my little bird stuff all out in front of my window. So
yeah, that's awesome. Let's see.
Oh, Joe just said I'm already live, but does that mean?
Okay, yeah. So I think people are starting to come in. So
okay, great.
I think we should go ahead and get started. So we are very excited to have Tracy Brenneman here. She is a board member of the Foster Family Alliance of North Carolina and a guardian ad litem in North Carolina, among many other things. And she's going to talk with us today about working with guardian ad litems.
All right. So good morning, everyone. I am thrilled to be here with you all. As Kate said, I am part of the Guardian Ad Litem program. I'm actually the district administrator for Judicial District 3B, which includes Carteret, Craven, and Pamlico counties. But the most important thing I've ever done is I am an adoptive parent of a child from the foster care system. So in my book, foster and resource families and adoptive parents are heroes. You guys are awesome. I had actually been training people how to be foster and adoptive parents for many years before I adopted my child, who was 14 when I adopted her. And boy, howdy, I thought I knew what I was talking about, but I didn't have a clue until I actually had her in my home and was parenting her. And I'm so grateful for the experience. But like I said, I know how hard it is to do the boots on the ground 24/7 of fostering and adopting. So I'm just honored to be here with you all. So I'm going to start out with just a little bit of a history lesson, but I promise you guys, I'm going to try to make sure it's not boring history because most people don't like history. So just so you know, there is a reason for there being a Guardian Ad Litem program, but what is that reason? Well, in the 60s, there was a national movement to make sure that children in foster care actually had a voice in this whole process. Because basically kids would go into the foster care system and just disappear. I know some of you guys are probably thinking, well, that still kind of happens today. And certainly kids do stay in care longer than we want them to in many situations. But back then it literally was almost like a life sentence for kids. So people started to talk about how we need somebody who can be a voice for these kids. So in response to the Federal Child Abuse Prevention and Treatment Act, which you guys have probably heard about before, CAPTA, one of the things that this required was for legal representation for juveniles to be appointed in child welfare proceedings. So in 1977, there was the first guardian ad litem statute in the state of North Carolina that gave judges the ability to appoint a guardian ad litem, an attorney actually, as a guardian ad litem in cases, but it wasn't mandatory. So when the program first started out, the only people that were guardians ad litem were actually attorneys. And if you've ever lived in another state, you might have seen that in many states across the country. That's still the model that they use, that they're only using attorneys. But we're going to talk about why ours is a little bit different. In 79, because attorneys were doing a thorough job as GAL, and the judges really liked the fact that they were getting this extra valuable information from these attorney GALs that helped them make the best decisions in the best interest of children. And they really liked that. So in 1979, they amended the statute to require the appointment of GALs in all abuse and neglect cases. So then in 1983, the office of the guardian ad litem was created in North Carolina as a point of law. And the purpose was to implement that volunteer and attorney co-appointment model of representing children in juvenile court. So by 94, there was a local GAL program established in all North Carolina judicial districts. So wherever you are, there should be an office of the guardian ad litem in your judicial district. Many of the judicial districts cover several counties, some only one, but most of them have several counties. So when does the guardian ad litem get involved is a question that we get a lot. So whenever DSS has decided, that a child's not safe for whatever reason, they're going to file a petition with the court, spelling out what those allegations are, what those concerns are. Oops, let me make sure I'm doing this right. What those concerns are. And when that petition is filed, that's when the law says that a guardian ad litem shall be appointed. Now, they are appointed always if the allegations are involving abuse or neglect, or both. And if a juvenile is alleged to be dependent, the court may appoint a guardian ad litem. So it's not required if the only thing alleged on the petition is dependency. And dependency is a very specific definition under the law in North Carolina. It basically means that there is no parent, guardian, or custodian responsible for the juvenile's care or supervision. Or it could be that the juvenile's parent, guardian, or custodian is unable to provide for their care. For example, someone who has maybe severe medical issues or severe mental health issues, and they are just not able to take care of their kids. So if the allegation is strictly dependency because of a situation like that, the judge may or may not. To be honest, a lot of the districts across the state just don't have enough guardian ad litem volunteers to cover the required abuse and neglect cases. So you may often see situations where children who are only alleged to be dependent don't have a guardian ad litem, which we don't like, and which is why we work very hard to recruit volunteers, because we would like for all children in the foster care system, regardless of the reason, to have a guardian ad litem volunteer. And I'm going to give you guys some ideas later on about how you can help us with that. And Kate and Joe, if there's any questions, feel free to stop me as I'm going. So what is the role of the guardian ad litem advocate? Well, they are going to dig for details in the case. And I'm going to talk a little bit later more about what that actually looks like. But they really do their own independent investigation separate from DSS. We are not the Department of Social Services, and we're not affiliated with the Department of Social Services. Doesn't mean we don't work in partnership with them, because we do. But we literally are even in two totally separate branches of the government. The Department of Social Services falls under North Carolina DHHS. The Office of the Guardian Ad Litem is on the judicial branch of the government under the Administrative Office of the Court. So those of us who are GAL staff are actually court employees. And then, of course, our volunteers work under our supervision. They're going to collaborate with others involved in the case. That would, of course, include social workers, since you guys certainly know that every child comes with at least one of those, maybe more, depending on where the case is. They talk with the teachers involved for the child, daycare workers, doctors, therapists, and of course, they should also be talking with you all as the caretakers for the children. And again, I'll talk a little bit more why that's so important, that they have that collaboration with the resource parents involved on the cases. They're going to recommend what they think is best for the child. Best interest of the child is our core tenet. All of our guardian ad litems are supposed to be child focused, and their ultimate goal in everything that they do is to recommend to the court what they think should be the best outcome for the children that we represent. So they are the voice of the child. As I had talked about earlier, in the 60s and for many, many years, there really was no one to speak for the kids. So they're supposed to spend time getting to know the child and what that child wants to see happen. That's so important that the guardian spends time doing that. They're going to monitor the case to completion. And as you guys know, sometimes these cases, well, let me rephrase that. Rarely these cases are a few months. Often they're a year or more, or many years, unfortunately, still in some cases. And our guardian ad litem volunteers are, we ask them when they sign up to be guardians if they're willing to commit to being a part of this child's life and be their voice for the duration of these cases. So until that child reaches permanency, whatever that might look like, the expectation is that the guardian ad litem would continue to be their advocate. So when you have placements that, may have come from another home and they've been in care a while, hopefully they're going to have a consistent person in their life, and that will be the guardian ad litem. And a lot of times, as we all know, unfortunately, because of the turnover with social workers, especially now, it seems like social worker turnover is at an all-time high, at least from what I've seen. It's really important that they have someone consistent in their life, and often that one person is going to be their guardian ad litem. They also are required by law to keep all records confidential, and I'm going to talk about that a little bit more later as well. Okay, Joe and Kate just checking in to make sure I'm still coming through okay. I hope that's a yes. I can't see anybody, so I'm hoping you all can still hear me okay. Okay, well, I'm going to keep it moving. So one of the other questions we get is, why do you use volunteers? Because in some states, it's attorneys that have to be the guardian ad litem for the child. Nothing against attorneys, they're great, but attorneys definitely have a legal focus. So there's a lot of reasons why volunteers are important. After the attorney GALs began to represent children, the state did some evaluation of the cost and effectiveness of attorney representation. And they decided that citizen volunteers could actually be trained to perform the non-legal aspects. So this allowed the attorney to focus on the legal part and the procedural aspects of the case, while the guardian ad litem focuses on the child. So some reasons why we so value our volunteers and see them as, as essential to our program. One is because they have the time. Our volunteers come to us from all walks of life, but we do make sure that they understand that being a guardian ad litem is not your average volunteer experience. I always say it's not like going down to the soup kitchen, although that's a great thing. But this is much, much more involved. So we try to make sure that they get that and that they're going to have that time.
Tracy?
Yes, ma'am.
Hi, honey. We have a question for you.
Okay.
If that's what you want to do, right?
Sure.
We go?
Absolutely.
Okay. So Robin Reese is asking, what do you do if you're assigned a GAL that either isn't that involved with the child or does not act in the child's best interests? We literally had one tell us custody shouldn't have been taken, but it should have been buried under the rug.
Okay, that's interesting. Well, the guardian ad litem program in every district does have guardian ad litem staff. So that will probably be a guardian ad litem supervisor or the highest rank, I guess, or highest management would be the district administrator. So for example, in my area, I have 2 guardian ad litem supervisors that cover the 3 counties, and they are the ones that the volunteers directly report to. Their job as supervisors is to make sure that the guardian ad litem is having that time with the child, that the recommendations they're making make sense. They literally review every court report that the guardian ad litem completes before it's even seen in court to make sure that, that what they're recommending, does have a basis in the evidence that they found. So if you have concerns that maybe the guardian ad litem is not spending enough time or is not, making what you believe to be sound recommendations, you could certainly call and talk with their guardian ad litem supervisor. You could talk with the child social worker who also would, reach out to either the guardian ad litem or the guardian ad litem supervisor. But it's kind of like anywhere. There's chain of command, if you will. And if you feel like they're just not really listening or doing what is truly in the best interest of that child, I'm sure that the program there would want to hear about that. Keep in mind, a lot of times guardians ad litem will have information that you might not. And we're going to talk about that a little bit later because they do have access to a lot of things that not everyone does. But that could also be part of the reason why their recommendations might not seem in the best interest of the child to you. I hope that helps a little bit, but that would be my recommendation, to reach out to the social worker and or the guardian ad litem program.
We have one more question.
Okay.
Valerie Thomas asked, I had a GAL that said she was an attorney. Does that mean she was still a volunteer?
It's very possible because, as I said, our volunteers do come from all walks of life. Generally, I wouldn't say probably. If they are an attorney that's currently practicing, they shouldn't be practicing as a guardian ad litem for children in a county that they might have any other representation going on. For example, if they're representing parents in DSS court, it would probably be a conflict of interest for them to be the guardian ad litem for a child in DSS court. But we do have, sometimes we have retired attorneys. In fact, I have some in my county, in my district, that make great guardians because they kind of understand the legal process and all. So it's highly possible. And the other thing is, in some situations, it's possible that the judge will appoint an attorney as a guardian ad litem for a child who might have some mental capacity issues. And that would be kind of like a different kind of guardian ad litem. So that's possible that that attorney is acting in that position. But all of our guardian ad litems for DSS children are generally going to be volunteers. So, but it's possible that they could have been or may still be an attorney. Mm-hmm. Anything else right now, Joe? Okay.
Nothing right now.
Okay.
Back to you, Tracy.
Thank you. The other thing that's really valuable about our volunteers is that they're not part of the system. They don't have the mandates, the policies, the rules and regs that DSS and others have. They are here solely to advocate for what they believe to be is in the best interest of the child. For example, DSS has to do diligent efforts with parents. It's federal law, that they work and give parents every opportunity, which I know that you guys as foster, I'll just say as resource parents, because I don't want to miss anybody, as resource parents can get really frustrated about, because it's like, wait a minute, these folks really aren't doing anything. Why are we still, focusing on reunification? And the guardian ad litem, while we certainly support and believe that reunification is the best plan for kids when it's the best plan, when it's safe, they can decide, sooner than DSS sometimes, that it's time to change the focus. And they may decide to go to a plan of custody or guardianship or even adoption, sooner than DSS would, because they're not bound by those same federal mandates. They are here solely to ask themselves, what do I think is the best thing for this child in terms of their permanency and in terms of their well-being? And that's what I'm going to recommend to the judge. I mean, of course, it should be based on the evidence they found, not just on feelings, but they can advocate for whatever they think is best because they're not part of the system and don't have that system focus. Another thing is they can focus on one case. Now, sometimes our guardians have more than one case because they have the time, and that's fine. Our best practice, though, is to have one guardian for one child or one family of children at a time. Unfortunately, you guys have seen how overwhelmed social workers are. I was a DSS with the DSS system for the first 29 years of my career before I moved to guardian ad litem. So I've been there. I've been a CPS social worker, a foster care social worker. I've been a supervisor in those arenas as well as a program manager. Also worked at the state and federal level. It's hard what they do. They have way too much to do and not enough time. So even when they really, really care and are doing the best that they can, they still can't give 100% of their time and focus to the one child that you guys care about, that you're caring for. Our guardians ad litem can do that. So they're never going to have that case, or shouldn't have that caseload of 15 kids like a social worker does. Sometimes they see things that we don't always see. Again, because they are all unique individuals, and they have that fresh perspective because they're not system folks. Sometimes they can really provide some valuable insight, and they also bring their own life experience to the table. Most of the guardian ad litem volunteers that you'll see have lived in their community for some time, and they know their communities. They know the resources, they know the challenges of the communities that the children come from. So that can be very helpful, particularly resources, because they know what's out there. They bring integrity to our program. And we say that because when you have someone who is voluntarily giving their time and energy away to a cause, that just automatically shows you that that program is worth something. And even more for vulnerable children to see that there's someone out there that's advocating for them who's not a paid employee, it can really reinforce their value and show them that someone cares. And here's a big one. We use our volunteers because they're effective. The model that we use of co-appointing a volunteer with an attorney advocate to speak for the children in court provides that strong, competent advocacy to the children who need it. So even though most of our volunteers are not attorneys, in each district, you're going to see at least one attorney advocate, and maybe more, depending on how big your district is, who is actually in court representing the children. Okay, they are the attorney for the children, but they stand up in court with the guardian ad litem volunteer to be sure that all of the child's best interest concerns are represented to the judge. And then we use volunteers because they care. Our volunteers go through a rigorous screening process. It's actually not unlike what you guys went through when you became licensed. Those of you who are licensed, they have to go through 30 hours of pre-service training. They have to do court observation. They have to do the full background checks and all, the RIL check, all of those things that you guys had to go through as well. And all of that happens before they're sworn in before a judge. And they know that the expectation is that they're going to advocate for a child from beginning to end, and that it can take years. And they do all of that because they want to make a difference in the life of a child. So who is qualified to be a GAL? Well, you have to be at least 18 years of age. Although, again, because life experience is important, we may or may not take somebody that's 19. It would just really depend on the person. I do have some younger guardian ad litem advocates who do an exceptional job because they've had some life experience that's really put them at a place to represent. You have to be willing to complete that extensive screening and that initial pre-service training. You have to have that sincere concern for the well-being of children. See, doesn't it sound a lot like you guys? Have that commitment to advocate for a child until that safe and permanent home is established and the court involvement is no longer required. They definitely need the ability to be objective, non-judgmental, and culturally competent. And we do spend a lot of time in our training trying to, help them to become that way. We also do very much, you guys probably, hopefully, have heard the term mutual assessment. When you became licensed, part of the process of going through TIPS MAP or whatever training process you went through, that was so that your agency could decide if you guys were right for the job and for you to decide if that agency was right for you. And we kind of do the same thing with our guardians. We go through that mutual training process to make sure that they can do this, that they can be objective and non-judgmental, and that they are open to supporting people from all kinds of backgrounds. We want them to be able to act respectfully with all of these folks, and also keeping in mind that most of the families that we're working with are going through crisis because of what's happened. Certainly, we know our children have experienced trauma just by the virtue of the fact that they're in care. And they have to have good verbal and written skills because our guardians, they need to know how to talk to folks. They need to know how to ask questions. They need to know how to engage with kids. And they have to write a court report that becomes part of the legal record. So, being able to, take all of the information that they gather and put it into a well-written court report is extremely important. I don't know how many of you guys have had the opportunity to be in court, but if you have, you've seen how important it is that anyone who's testifying is able to make it very clear to the judge what they think needs to happen and why. So the guardian ad litem needs to make sure that all of that information is in their court report and that they have the ability to explain that if questioned by anybody, the parents' attorneys or the DSS attorney or the judge. So what happens when the GAL is appointed? Well, hopefully lots of things. One of the first things that we often tell the GAL to do is to read the DSS records and talk to the social worker. You guys have probably seen that in most counties, we don't have that knee-jerk reaction where we just drag kids into foster care without trying to help families first. Back when I first started practicing in the 90s, we were real bad about just, asking a few questions and then filing a petition and putting kids in foster care. And we realized we were harming children and families by doing that. So most of the time, DSS will probably have already done quite a bit of work with that family and will have a lot of records and information that's important for the guardian ad litem to know about. So they're going to probably start or at least get a lot of their information on the front end so that they know who to talk to next, okay? They're going to contact you as the person that's caring for that child to arrange for a time to meet and talk to the child. They'll do that, as often as they think it's necessary, and certainly they will respect or should respect your time and your schedule, and in setting up the time to do that. But it is really important for the guardian ad litem to have that time to get to know the child so that they feel comfortable telling them, what they think's important. Part of the guardian ad litem's responsibility is to make sure that children are safe and that their needs are being met. So they will need to see your home. They're not there to, to do the whole white glove test, to pass judgment on you guys on your housekeeping skills or anything like that. But they are there just to be sure that the child's comfortable, that their needs are being met, and that there are no safety concerns. And I hope that the experiences that you've had with guardians ad litem were positive and that they were respectful when in your home, because that's something that we do talk with them about. They're also going to talk to the birth parents and anyone else they deem relevant to the case. So as they go through those records, as they talk to the child, as they talk to you guys, that's going to give them clues about who they need to talk to. They're also going to review other records related to the child. So school records, mental health records for the child, medical records, because by law, they are allowed to obtain any records that they deem relevant to the case, even if they are confidential. So when a guardian is appointed, they actually get an appointment order signed by the judge that explains that law, allowing them to get the information that they need. Of course, there are some federal laws that trump that, which we all know. So they, can't get mental health or substance abuse records for the birth parents unless the birth parents sign releases for them to do that. A lot of times they will, which is the other cool thing about guardians. When families realize that they're not the social worker, sometimes they actually will talk to the guardian ad litem even more than the social worker, or be willing to allow them to see records. So that can be very helpful as well, to be sure that the judge has everything that they need. They will take all of this information that they gather as they go, and they will write a court report that will be presented in court, and they will testify to that as well. So any questions so far? I wanted to take a quick few minutes to allow for questions if you guys have any.
I'm not seeing any questions so far, Tracy.
Okay. I hope that means I'm doing a good job then.
You are rocking it.
Okay. All right.
There's just been a few comments about some GALs who have not seen the child since they've been in care.
Okay.
So maybe you could address how foster parents could deal with that if
sure
they have a GAL, but the GAL hasn't seen the child yet.
Okay. So one thing I will say, guys, is that during the time of COVID, basically the state put all of the guardians ad litem on lockdown. In other words, they were not allowed to have any face-to-face contact with their child clients. They weren't allowed to go to meetings face to face. They really couldn't do anything face to face. Now, they should have, though, however, still attempted to make contact through virtual means. So a lot of our guardians have been doing Zoom meetings with the kids, Zoom meetings with the foster, adoptive, and kinship parents, attending CFTs and all via Zoom, or phone contact was okay as well. So it's possible that maybe some of the not seeing them as much was due to COVID. However, that there has been some relaxing of that, and the volunteers now are allowed to see their child clients again, as long as everybody is comfortable with it, particularly you guys, that you're comfortable with them coming to your home, and that everyone follows any guidelines of the CDC, which I think recently got relaxed even more. So as long as everybody's healthy and being safe, the volunteers are again allowed to see their child clients. So hopefully you'll begin to see that things kind of return to quote unquote normal since those things have been relaxed. Now, if they just haven't made contact at all, again, I would, encourage you to mention that to the social worker or contact the GAL office and ask for the supervisor, because again, that is part of what our expectation is. It's kind of hard to write a court report and express a child's wishes if you haven't seen them. So I definitely would encourage you guys to mention that to the local program office, because that needs to be happening. And again, you'll want to also make sure that a GAL was appointed, because if you have one of those cases that's dependency only, it might be that there is not a GAL appointed. The other thing that I didn't mention earlier is that in some districts where they don't have enough volunteers, the GAL staff is the one who will have to make the contact with the children and write the court reports. And as you can imagine, that can be challenging if they have a lot of cases that are not covered by a volunteer. Fortunately, in our district, all of our children have a volunteer, and we are actively recruiting more because, unfortunately, due to the stresses of COVID, we're beginning to see an uptick in the number of cases. So it is really important, but it also is law that if a child is alleged to be abused or neglected, that they do have representation from GAL. So I definitely would encourage you to reach out to the GAL office if you have not seen or heard from anyone on your child's case. So here's the fun part, okay? What can you guys do to help the GALs? And in a minute, I would love to hear from you guys, anything that you think guardians can do to help you guys. One of the most important things that you guys can do for the guardian ad litem is to communicate. All of the GALs in the state now actually are supposed to have their own professional NCGAL volunteer email account. It's a secure email process where you guys can send information to them about your kids that you think is important for them to know, and they can respond in a way that's secure. So some of the things you would want to share with them are just some updates about the child's progress. You could send some pictures. You could send information about school. If they're involved in some kind of, sports or awards things, just anything that you think is important for the guardian to know. That also helps them know how the child is doing, which is something they have to report to the court. You can communicate with them to let them know when it's a good time to contact you or to come to see the child. I have had guardians say to me that the foster parents sometimes won't call them back. I think part of that is because sometimes foster parents may not understand what the GAL's role is, and you guys are just trying to protect the confidentiality of the child, which is exactly what you're supposed to do. But if a guardian ad litem does reach out to you, you can certainly verify them with the local GAL office or social services if you would feel more comfortable doing that before you reach back out to them. But it is important, to get in touch with them as soon as you hear from them so they can start their job of getting to know the child and working on that relationship with the child. Definitely let the GAL know if the child has needs. Again, part of the guardian's role is to be checking on the well-being needs of kids that they represent. So if the child has needs, particularly ones that are not being met, let that guardian ad litem know. For example, I know that sometimes or most of the time, you guys know if there's a need for therapy or for some other therapeutic intervention, or maybe there's a medical need or a connection need. That's a big one, where a child hasn't seen their siblings, or they want to call and talk with one of their birth parents, and that's not happening. Those kinds of things are important for that child's well-being. And if it's not happening, you can let the guardian ad litem know about that, and they can assist in advocating to make sure those needs are met. In some districts, they also have, I don't know if you guys ever heard the term 501c3, but that's the federal approval for a group to be a nonprofit organization. And in some districts, there are nonprofit organizations that are dedicated to supporting the GAL program and all the children that are represented. For example, in my district, we have Friends of 3B. They're not affiliated with us in terms of they're not part of the government. I don't run it. It's handled strictly by some of our volunteers who started it. And what they do is they raise money to pay for things for child clients that DSS is unable to pay for. For example, we had a child in a group home who, because of COVID, the kids were doing school via computer. Well, in this group home for 6 boys, they had 1 computer. So this kid wasn't doing that great in school anyway, and he was having to wait to have his turn to use the computer. So his guardian ad litem contacted our Friends of 3B and said, hey, can we buy this kid a laptop because he really needs to have that educational time? And they approved it and were able to purchase that for him. Sometimes it can be other medical equipment or things that Medicaid doesn't cover and DSS doesn't have funds for. So you might want to check with your district GAL office to see if they have something like that in case any of the children in your home might have needs that are going unmet. So make sure that your guardian ad litem is aware of that. Because the big thing, let's see, and I forgot to do my thing here, is that the more information they have about the child, the more sound their recommendations will be. And that's the important thing. If they don't know, you don't know what you don't know, right? So we want to make sure that you guys communicate with them what you think is important too, so they can always be looking into that. We hope that you'll encourage your foster child's relationship with the GAL. You can help them understand that the GAL's role is to get to know them, find out what their wishes are, and tell the judge what they think is best for the child. And that's pretty much it. Let them know, no, they're not a social worker. They're just a volunteer that wants to make sure that you're okay. And they're going to come and talk with you. And it's okay to tell them, what you want and any concerns that you might have. And that can really help a lot. And the other thing is kind of like what you see when people separate, or maybe even with social workers, talk positively about the GAL in the child's presence, even if you don't necessarily feel that way about the GAL. Because we do know that, GALs are people, and not all of us like all of us. It could be a personality conflict. It could be that the GAL is recommending something and you don't particularly agree with that. But in order for them to figure things out and do the best job that they can, it's important that the child feel comfortable talking with them. So, that's helpful for us is if you help the child to feel comfortable when the GAL comes to visit. Involve the GAL. Let them know about appointments that the child has, doctor's appointments, school meetings. Those IEP meetings are really important to have them there. Treatment team meetings, if your child's involved in a therapeutic process. The positives too, those sports events, those award ceremonies, let them know when these things are happening. Doesn't necessarily mean they'll be able to come to all of them because, some of our volunteers also work full-time as well. So they may not be able to be at all of them. But again, it gives them that valuable information about what's important to the child and how they're doing. It's important that our kids, you guys all know, I'm sure, the reasonable and prudent parent standard. We want our kids to feel normal. We want them to be involved in normal things. So it's important for the GAL to know, that that's happening for those kids. And here's a big one, guys. We really need you to remember what the guardian ad litem's role is. They aren't the social worker. So things like transporting, they are absolutely not allowed to transport children. So they should never do that, or anyone else for that matter. They also are not allowed to personally buy things for the child. That's one of the hardest things for our volunteers because they want to. They're good, they're helping people. They would like to be able to do those things. But the reason they can't is because we never want to create any sense that children are telling a guardian something strictly because they're trying to please the guardian. If a child knows that every time the guardian comes, they're going to get a present, they may think, well, I want to tell the guardian what I think they want to hear. And we don't want that. We want kids to tell us the truth. And to tell us, what they really want. So guardians should not be buying things for the kids. The other thing is that the GAL is not a lawyer, okay? Some of them might be, okay? But even if they are in this process, they are not attorneys. Please don't ask them for legal advice and don't ask them to explain court proceedings to you. They might try, and I hope they won't. I hope they'll say no. But my concern would be that because they're not attorneys in these matters, they might give you information or interpret the information in a way that's not 100% accurate or could even be misleading. And that's just not their role to be there as an attorney. So always make sure you get that information from the social worker and not the guardian ad litem.
Tracy, darling, I have some interesting comments in the chat.
Okay.
That I think can contribute to this conversation.
Great.
One of the folks wrote, it's actually Karen Lauder. I was a GAL for about 2 years. Unfortunately, I never witnessed the data from the GAL to be viewed important enough to change DSS's recommendations, which is interesting. And then it was followed up by Rebecca and Jamie Mazingo. They said, Karen, I have seen one of our GALs express this same frustration in one of our cases. Okay. Luckily, I've seen several others be highly respected, and their input was crucial to the outcome of the child's care. So they're seeing both sides of that. And I think one of the things you're bringing up here kind of ties to that, is what can foster parents do to help the GALs in that process. Do you have any thoughts on that?
I do, absolutely. And I'm really glad you guys brought that up. So one of the biggest or most important part of my role as a district administrator is to make sure that our program is seen with the utmost respect and that our guardians, are considered knowledgeable and that their integrity is never called into question. Not only myself, but also my staff. When we have new guardians come in, that's part of our training process, is to make sure that they understand their role, and that they are never misrepresenting the guardian ad litem program, or or doing anything that could call the integrity of our program into question. And I'm not saying that, wherever you guys are, don't tell me, has ever had anything happen, but we also have to keep in mind that we do have volunteers, and sometimes volunteers can make choices or say things that could call the entire program, into question. For example, you guys know you've probably had a social worker that you were like, what the heck, why is this person even a social worker? And that unfortunately can have an impact on that whole agency and how people feel about the whole agency. I mean, that's true of any business, right? So that could happen in a guardian ad litem program. So our job, and part of my role, is to have that relationship with our district court judges so that, that they understand what kind of training we're doing. And we do lots of training in our district. Not only do they get pre-service, but they're required to have at least 12 hours annually of additional training. And we actually offer them even more than that. To be sure, again, that they're making sound recommendations that the judge is going to respect. So it's, it may be that where you guys are, there was a faux pas or something with another guardian. I really couldn't say, but that is something that the district administrator and the guardian ad litem staff try to work on. And, that's also something too. I don't know what your relationship is with your social workers or your GALs, but the district administrator where you are, might want to know that if there is a guardian ad litem that you feel like might be adding to that concern, they may want that information so that they can address that. I know I would want to know, because it might be that the guardian ad litem, doesn't even realize what they're doing is not okay. So I hope that kind of answered that question, but I'm glad you guys brought that up, because that is definitely key, that our program integrity is always intact.
And here's another one that I think is in line with it, Tracy, my dear. And that is from Alan Brown. Is there a requirement that DSS is aware of all foster parent communication with the GAL?
If there's not on our side. Now, your agency, if you're licensed by an agency, they might put that requirement on you guys. I don't think I've ever heard of one doing that, but certainly on our side, our guardian ad litem volunteers, they can talk to anyone at any time that they deem relevant, and they do not have to let DSS know that they're doing it. Now, again, we try to be good partners with DSS and everyone involved, and would certainly share information with DSS that we thought was important for them to know, for the benefit of the child. But we certainly don't have to ask their permission to talk to a foster parent or to talk with the child. I mean, we legally represent the child in court. So again, you might want to check with your agency, I guess, to see if that's a requirement, because it's not on our side.
Well, in line with that question, Tracy,
yes,
Angela Canada asked, is there a requirement of the frequency of visits or video visits between GAL and the child?
We ask them to do at least monthly contact, again, because they're volunteers. We don't put any more than that on the parameter. However, we also try to make sure, that they understand it's important to see the child as much as they need to. So, for example, especially in the beginning, when they're trying to get to know the child, I think many of our volunteers try to see them more than that. But I guess as the requirement piece would be at least monthly.
And one of the GALs, there's a woman in here who is a GAL.
Yes.
And she's saying sometimes that there's such a distance travel-wise between where the guardian ad litem is and where the child is. Sometimes it's impossible to make those trips. Mm-hmm. Yeah. So, and that's another concern that that was brought up. and
Yeah.
she's also, and this Mrs. Missy Franklin, and she's also a foster parent. So
Well, thank
she's
you.
seen both sides of it. So I just
Awesome.
wanted to let you know about that comment.
Absolutely. And thank you, Missy, for that. And thank you for your service on both arenas as well. So yeah, unfortunately, most of the counties are not always able to place their children in their county. We used to have a process prior to COVID where one district could request a courtesy visit from another district. So a guardian ad litem, say if I have, I'm at the coast, say if there was a child moved to Asheville for some reason, we could request a guardian ad litem in Asheville to go see that child on our behalf. However, I've heard, and this isn't 100% sure, guys, so don't pin me down on it, but I've heard that they may not go back to that because we've been able to do a lot of communication virtually. And that if the child is, if they're able to effectively advocate for the child through virtual means when they're placed far away, they may continue to do that. So Missy, maybe talk with your GAL supervisor and see what plan they're having, or, like I said, I don't think that's a hard and fast thing just yet. I've just heard that might be happening. So great comments, guys. Thank you all for that. So back to our thing as far as the GAL's role, just a couple of other things I wanted to throw out there. And this is a big one too, guys. The GAL is not your coffee and chat buddy. Now, we hope that you're comfortable enough with them for them to have coffee and chat with you guys, but please don't ask them for information about the case or the birth parents or anything going on in that case, because it is a breach of confidentiality for them to share any information with you. And that's the law. Now, I know sometimes guardians fall into that trap because it's easy to do. But they really are not supposed to be relaying information to you about, a birth parent's progress, or, if they heard they didn't pass their drug screen the other day, or all of those little things that really should not be coming from your guardian ad litem. If you have questions about that and you feel like you need to know, I would always steer you to the social worker. So just keep that in mind, that you really shouldn't be going to them for case information at all. Now, they can certainly, if you guys, for example, if you guys feel like there's a therapeutic need for a child and they have some insight about that and want to talk with you about what they think might be good for the child, that's perfectly fine. But they just are not supposed to be sharing any confidential case information with you guys. Okay. And that's true whether you're a non-relative or a relative. I think that sometimes when relatives are the caregivers, it's even harder for them to remember that they shouldn't be sharing information, because I think sometimes they think you guys probably already know. So that's one thing we're working with, because we don't want them to get into any trouble, because it would be a violation of law for them to share that kind of information with you. And here's another big one, and I hope this doesn't sound painful to you guys, but it's important to remember that the GAL is not your advocate. They cannot and should not be advocating for what you guys want, for what your best interest is. That doesn't mean, that at some point they might not advocate for you to be a permanent placement for your child if that's something that you want. But that advocacy should always be centered on the child and why that placement would be in the child's best interest. So again, when you meet with the guardian, it's perfectly fine for you to say to them, hey, if this child's case plan changes, I'd love to be considered, as their guardian, custodian, adoptive parent, whatever it might be. Because that's important for them to know. But just keep in mind that if they do choose to advocate for that, it will be because it's in the child's best interest, not because, you guys have become close and they, and that they're your friend and they're your pal. Again, I hope you guys have that comfortable relationship, but their advocacy always has to be focused on the child. So just wanted to remind everybody of that. So one more thing that you guys can do, I think I have just a couple of minutes left, is volunteer. So if you get full, you adopt all those kiddos and you can't be a foster parent anymore, I got a great place for you to go. Or even if you are still fostering like Missy, and you would like to help out in another way, being a guardian ad litem would be awesome. I mean, you guys know the system, you know the kids, you know the challenges and the rewards. And I know that any district would be happy to have you aboard. If you're currently fostering, of course, you know, you probably wouldn't be a guardian ad litem in the same county that you're taking kids from, because again, that could be a conflict of interest. But after you're done, I've had several foster parents who just, you know, love these kids and really want to continue to make a difference, but they're full now, have decided, you know what, guardian ad litem is a way for me to continue to be involved and to make a difference. So we hope you'll remember that. And the other thing is if you're a member of any organization, anything, you know, faith community, Rotary Club, dog painting club, I don't care what kind of club it is, I know that your district administrator would love to come and speak to them about the guardian ad litem program. There's just a lot of people, I can't tell you, all the time I ask people, you know, are you guys familiar with guardian ad litem? And I get no. So, you know, our goal is to make sure that everybody knows about our program and our need for volunteers and what it is that we do to try to help make a difference for kids in foster care. So that is everything I have. And I think I'm right on my time. So what questions? We got a few minutes for questions, I think. Am I right, Joe? Or comments?
Yes, we do have time for questions. In fact, I think we have about 10, 15 minutes for questions and comments.
Okay.
So just ignore my magic wand.
I feel like a fairy.
My great niece loves that. Okay. All right. So we do have a comment here from Missy Franklin.
Yes.
She also said, thanks for your feedback. The virtual option has made it much easier to have monthly contact.
Awesome.
And she also said that sometimes a volunteer seeks to serve as GAL because they have seen the need for volunteers, i.e. foster parents, former social workers, teachers, etc. In many cases,
yes,
they may not be retired or otherwise in a position to devote as many hours as some may think they should. Yeah. Attending meetings, preparing reports, and staying informed takes many hours each month. In my case, I have a house full of kids with lots of needs. So just trying to keep that in perspective is helpful. And she says, great session.
Yeah. Well, thank you, Missy. Yeah. And I'm glad that you said that too, because on the website, it actually says on the Guardian app, which I'm going to give you guys in just a minute, that it's like 8 to 10 hours a month. And we are really trying to get that 8 to 10 hours thrown out the window. Some cases, it might only be 8 to 10 hours a month. Some it may be more. And sometimes with our long-term kids, it may be less. So we really can't pin a time frame on it. It just really depends on the case and the child's needs. So I really appreciate all those comments, Missy.
Tracy, I wanted to just have you bring out what drew you to going to the Guardian Ad Litem program, because you've been a parent, you've been a social worker, you really, some of you who know Tracy know she's a woman of many talents.
Thank you, Jeff.
So I just wonder what drew you to the program that you could share with the group.
Yeah, it's funny because in all my career as a social worker and in being in child welfare, it was always interesting to me how when the guardian ad litem, specifically the district administrator, but also the guardian ad litem in the counties where I served, when they would come in the room, there was this automatic kind of, okay, the guardian ad litem is here, and they're probably going to have something to say. And, you know, most of the time it was positive. Sometimes it was like, oh no, the guardian ad litem's here and they're going to have something to say. But most of the time it was an element of respect. And I always thought, wow, how cool is that? And then when I really learned about how the focus of guardian ad litem is just, you know, we are just here to express the child's wishes and tell the judge what we believe is in the best interest of the child, period, and not have to worry about mandates and all of that. It really made me want to be a part of this program. And I also thought, because I do understand the challenges that folks on the social work side have, that I could be a good partner and help my volunteers be a good partner. Because that's the thing, is when people are working in silos or when things are adversarial, you just don't get stuff done, you know? So when we can have a good partnership, even if we don't agree, you can still have a good partnership. And that's when you can do things that make a difference for kids.
No, I really, really like about what you said about that partnership piece, is that you're not always going to agree, but your common denominator is what's best for that child.
Absolutely.
So Rebecca and Jamie, I love what they say here. I've never understood why the GAL wouldn't receive a stipend of some kind through the state. Their role is in depth, and maybe that would help retain, recruit, and decrease burnout and turnover. Another person, I thought that was kind of nice.
Well, and actually, let me comment on that real quick, Joe, before you go to the next one. So yeah, one of the other things I didn't mention about the benefits of our volunteers is that they save the state a ton of money because of their volunteerism. And in fact, in fiscal year 2019-20, the time that volunteers put in that would have had to be paid to an attorney was over $12 million of taxpayer money that they save. So, so which makes my job harder, because I do, you know, want to retain, and all district administrators, you know, we want to retain these wonderful volunteers, and we try to do what we can to show appreciation with no money, because we don't have any money for that. But, you know, hopefully they get the support and all, that they do feel appreciated. And almost all my volunteers, you know, they're here for the kids. They do it for the kids, and they stick around for the kids, just like you guys, because y'all sure don't get what you're worth, you know, in terms of any kind of stipend or reimbursement. So
it's one person asked if they will have access to the presentation, and I'm pretty sure we are recording this, and that we'll be able to that you will have access to the presentation.
I'm happy to do this presentation for anybody, anytime, anywhere. So if it's not recorded or whatever, just in fact, here, I'm gonna go ahead and put up my contact information so you can see. This is the state website is volunteerforgal.org. Everything that you want to know about guardians is there, as well as a place to apply. So if you know anybody that has some time on their hands that you think would be good, you know, give them this website for us. And then also, here is my contact information. If when we're done, you guys think of something later on or have a question, you're more than welcome to reach out to me. It might be best to reach out to your own district if it's something, you know, you think would be specific to your district, but you're still welcome to reach out to me, and I can also always put you in touch with other folks if needed.
Tracy, can you just as we're ending up our questions here, could you share a story about a guardian ad litem who made a real difference in the life of a child? That's just, I know that you know a lot of stories, and I know that we need to be confidential, but just would you mind sharing one? Because I think it's really important for foster families to see how guardian ad litems can make such a difference.
Absolutely. So one thing that happened recently, and this is that whole dilemma, you know, between the DSS mandates and us not having those mandates. There was a situation where a child had been with a foster care placement for some time. I believe it was almost a year. And a relative was found, And the Department of Social Services said, well, okay, we've got a relative now, and the law says we have to place, this child with this relative now. And of course, we certainly would support continuing contact. In my opinion, and this is one of my soapbox things, we should do our best to continue connections for children, even when we adopt them, But in this particular case, we strongly believe that this child's best interest was going to be served by being placed permanently with the resource parent. That was the only family they had ever known. They did not know the relative, did not have a previous relationship with them. And we were like, no, the best thing for this child is to stay where they are. Why would we move them to place with strangers just because there's this, relationship, supposedly a relative? And the judge listened to the guardian ad litem, and the child was allowed to remain. Now, again, that foster parent fortunately was willing and realized the importance of that child still having a relationship with that relative, but they did not uproot that child from the family, and they were allowed to maintain placement there. So that's the kind of thing that the guardian ad litem, one of the things that guardians ad litem are sometimes able to advocate for.
Yes. Mm-hmm. And I just wanted to mention too, Tracy, guardian ad litems have such an in with the judges. And some of them have really effective relationships with the judges that no one else on the team may have. So that's another really powerful role of a guardian ad litem, I think, is that a lot of people don't have as much time with the judges as a guardian ad litem would have.
Yeah, and that's true. And they, and that's why we work so hard as a program to make sure that, that their court reports are thorough and have all the information, and that they're, comfortable testifying in court, because that goes to our integrity, like we were talking about earlier. And you're absolutely right. Because the judges do get to see many of our volunteers, several times as they continue to advocate for either that one child client or others, they get that reputation of being someone that judge wants to listen to. So you're absolutely right, Joe. Yes,
and we keep getting requests to make sure that your presentation will be available.
Okay.
And it will be.
Okay.
So I just want to thank Tracy for her wonderful presentation. Are there we have a couple of minutes left for any other questions you might have?
Now, I usually throw in my side gig, but but we didn't even talk about music for once, Joe, so that's a good thing.
I know.
People always ask me about my music.
I love it, Tracy. You can see Tracy at when we say Tracy rocks, she rocks on the stage as well as a presenter.
Yeah, just send me an email and I'll tell you about that part. So,
so Tracy, thank you so much.
Thank you.
Thank all of you for being here and your wonderful comments and questions. We really appreciate it.
Absolutely.
And hope you have a wonderful afternoon. Tracy, thanks again.
Thank you, Joe.
Okay.
Thank you all. Thank you for what you do. You're the best.
Bye-bye.